million were subject to the federal estate tax in 2009. In 2010, this law entirely repeals the federal estate tax. However, did you know that this legislation expires in the year 2011? That the federal estate tax will return at its 2001 levels, or a top rate of 55% on estates over $1 million. Are you aware that the federal estate tax in 2010 was replaced with a new federal capital gains tax on appreciated assets? What are the details of this new capital gains tax? Does this capital gains tax cause bigger tax problems for families than the former federal estate tax? Will Congress pass a new law setting new rates for 2011 and beyond? While Congress is hashing this out, should people with substantial assets take another look at their estate plans? What planning tools are available to assure that an estate plan will not be harmed by the new capital gains tax in 2010? Why is it important to review an estate plan? Are there any risks in deferring the preparation or review of an estate plan? Hey, can we talk a little bit about the current law? It's my understanding that there was a gradual increase in the exemption, so could we just give the viewers a little thumbnail sketch as to what that law looks like?
Sure. Actually, the government wants a significant amount of money when someone dies.
Mm-hmm.
And when someone dies, you have to value all of the family's assets at fair market value.
Mm-hmm.
But each person who dies has an exemption. And it's the exemption
What do you mean by an
amounts.
exemption? What do you mean by that?
It means, let's say, for example, someone has $3.5 million in assets, a single person. Mm-hmm. And if the exemption amount is $3.5 million, those assets can be passed to the family, the children, free of death taxes.
And that exemption has gradually been increasing. I believe it was $3.5 million in the year 2009. So here we are in 2010. Is there an exemption this year?
There is no exemption, but there is no estate tax. So we had this gradual increase in the exemption from $600,000 to $1.5 million to $2 million to $3.5 million last year. Mm-hmm. And this year there's no estate tax, federal estate tax whatsoever.
Okay, so in 2011 the exemption will return back to where it was in the year 2001, which was $1 million, and the effective tax rate will increase from 45% back to 55% where it was before.
Yes, exactly. While it would be a drawback to have assets subject to the estate tax system, the flip side of that is something called the step-up in basis.
Mm-hmm. So let's talk a little bit about I'm glad you brought that up, the unlimited marital deduction, because between husband and wife, you can leave one another an unlimited amount of money, but there's downside to that, isn't it? You lose your exemptions. Let's say we're in the year 2009, not 2010. We're in the year 2009, you're working with husband and wife to set up an estate plan. All they have in place right now are simple I love you wills where they leave everything to one another. The total estate value is $8 million. What should be done?
But to answer your question, you'd have $3.5 million sitting in the bypass trust, no federal estate tax because it's blanketed by the exemption. The Massachusetts exemption is only $1 million. As a result, you'd have a $3.5 million gross estate, you'd have $1 million exemption, and a $2.5 million Massachusetts taxable estate, which would cost about 10%, $250,000 without additional planning.
Okay. As I see things, you'd have husband and wife would have their living revocable trust. Each would fund the bypass trust with $3.5 million. You'd end up with a Q-tip for $1 million in order to cover the Massachusetts estate tax. We do, using that very same scenario, same husband and wife couple, only we're now in the year 2010. How does the planning change?
We'll answer it this way. What we've done is we've planned for the couple. We know that we don't know which spouse is going to die first. That's a challenge. So we put $4 million into the husband's revocable trust and $4 million into the wife's revocable trust.
Okay, but why do you do that? You just said earlier the estate tax is repealed. There is no tax.
Yeah, well, you're right, but these people probably did their planning last year. Well, the simple thing to do would be to have each of them give each other a power of appointment over each other's assets. So for assets that pass to somebody other than the surviving spouse, the maximum step-up is $1.3 million. If assets are left to the surviving spouse, there's an additional $3 million in step-up. So between assets that don't go to the surviving spouse and assets that go to the surviving spouse, the maximum step-up would be 4.3. Whereas under the old law, there was no limit to the step-up, and therefore the elimination of capital gains in the future. The best way to describe a Q-tip trust is Congress's version of how to leave assets to a spouse for marital deduction purposes, but without actually letting the spouse get the money. We refer to it as an I love you, but I don't trust you trust. And the surviving spouse cannot say where it goes when she dies. And when the surviving spouse dies, it actually comes back. It's like controlling things from the grave.
From the grave, yeah.
But it was Congress's response to the fact that there are a lot of second marriages. There are a lot of spouses that are going to get remarried, and you may not want to leave everything to a surviving spouse. So they have this thing called a QTIP, Qualified Terminable Interest Property Trust, which seems to solve the problem pretty well.
Yeah, it's also a good instrument to use where you have, you were mentioning several marriages, where you have a second or third marriage and you have children from a previous marriage, and perhaps husband or wife, depending on which spouse, wants to leave assets to those children, but the other spouse really has no attachment to those children. So a QTIP works really well, making sure that those children are provided for at some future time.
Without a doubt.
Congress has done the impossible. It has injected uncertainty into death and taxes. On December 31st, 2009, the federal estate tax was repealed after having been in effect continuously since 1916. But don't applaud yet. Without new legislation, the federal estate tax will roar back with vengeance in 2011. For the year 2010, Congress has eliminated step-up in basis for appreciated property. In other words, make contingency plans. No doubt the public is confused, bewildered, and confounded because of the lack of clarity and certainty. The new rules appear convoluted and in many cases very different from the old law. For example, many people who wrote well-drafted wills and trusts prior to 2010 now find, thanks to the new federal tax law, that these documents might now result in the effective disinheritance of a surviving spouse. Moreover, all the talk about Congress passing a new law has many families frozen, waiting for Congress to act. Even worse, it's not at all clear what kind of new law might emerge this year as Congress works against a backdrop of rising deficits and election year pressures. Lastly, a comprehensive estate plan prepared today is the first step in assuring that you, your family, and your assets will be protected sooner rather than later.